The requirements of Article 31A ARC to be complied with, P60, G.G. Boyvi Assistant Collector, 1965, ASCR 616 and Bihar Lee, NTL Reformsies, 1952, SCR 889J Gan Mohan Reddy, J. The Constitution. 24th Amendment is valid. Section 2 of Constitution. 25th Amendment is valid. The new Article 31C introduced by Constitution 25th Amendment is valid only if the words inconsistent with or takes away, or the words Article 14 and the Declaration portion are severed. The Constitution 29th Amendment is valid. pp. 555, 556. What the leading majority in Goloknath did not decide was whether Article 368 ITCLF could be amended under the proviso of that article conferring a power to amend the whole Constitution. The ratio of the decision in the Goloknath case is that an amendment under Article 368 is law within the meaning of Article 13.2, and Talat under Article 368, Parliament could not amend the Constitution to take away or abridge any of the fundamental rights conferred by Part 3 UF the Constitution. That question will assume importance if this court comes to the conclusion that Parliament cannot amend Art. 68 under proviso E thereof to take away or abridge any of the fundamental rights or amend Article 13.2, making it subject to an amendment under Article 368. If such a power exists, the question whether an amendment in Article 368 is a law within the meaning of Article 13.2 may not prima facie be of significance. There are two aspects to this problem. First, whether law in Article 13.2 includes an amendment of the Constitution under Article 368, and secondly, if this court holds that 1AW in Article 13.2 does not include an amendment under Article 368, then the question would be, has the Constitution 24th AMC-NDM and purported to exercise a power not granted under Article 368? Or in other words, are there any implied limitations to the amending power under Article 368 pp 462, 180, 3-36, SC Lendla 13 and 34, Supreme Court Reports, 1973, Sup SCR. On the construction placed on Articles 12, 13 and other provisions of Part I and A Tile 36, Article 1-2, does not place an embargo on Article 368 AWTN Arst. 13.2. It's that which may be made by the ordinary legislative organs p. 480J Article 13.2 does not place an embargo on Article 368 for amending any rights in Part I. To limit the extent and ambit of the power under Article 368 in which there is no reference to a law, by including within the ambit of the definition of law in Article 13.3a, for purposes of Article 13.2, an amendment effected under Article 368 is to restrict the power of amendment by a strained construction or to impute to the framers of the Constitution a lack of respect to the amending power by making the bar of Article 13.2 applicable to it by mere implication, when in respect of minor instruments they were careful enough to include them in the definition of law. A consideration of the conspectus of the various rights in Part 3 when read with Article 13R2 would prohibit the taking away or abridging of these sites by a law made by the Parliament, by the legislature of a state, or by executive action. This conclusion V1 will be substantiated if Article 13.2 is read along with each of the articles in Pat Ill. The object of incorporating Article 13.2 was to avoid its repetition in each of the articles conferring fundamental rights. Gene reading the articles in Part 3 with Article 13(2), the words "when law in accordance with law" or "authority of law" clearly indicate that law in Article 13(2) is that which may be made by the ordinary legislative organs. The assumption of Hidayatullah J. in Goloknath that the word state in Article 12 would mean all the agencies of the government, jointly or separately, is not justified. The prohibition in Article 13(2) is against each of them acting separately. The framers of the Constitution distinguished the Constitution from law or laws, making evident their intention by using the word law in contradistinction to the Constitution, indicating thereby that the word law, wherever referred to, mean only ordinary legislative law. Feels like Constitution means something distinct from it. Article 13(2) has A purpose, and that purpose is to emphasize the importance and the commanding position of the fundamental rights, pp. 480. The court, in a constitutional matter, where the intent of the framers of the Constitution as embodied in the written Constitution is to be ascertained, should look into the proceedings and the relevant date, including any speech which may throw light on ascertaining it. Unlike a statute, a constitution is a working instrument of government. It is drafted by people who wanted it to be a national instrument to subserve successive generations. The various stages of the Constituent Assembly proceedings, while considering the draft Articles 8 and 304, corresponding to Articles 13 and 368.